Edmonton Community Foundation is pleased to provide this Wills Week resource for Alberta-based will and estate information. It dovetails nicely with our usual role as a trusted resource for how organizations, large and small, enhance our lives here in Edmonton, and how you can create gifts that reveal your values in a way that fits you. For this session, we are very fortunate to have two lawyers who sit on our Wills Week committee joining us today. I'll introduce them both and turn over the session to the two of them. First, we're joined by Mike Simons. Mike works with clients in all areas of estate law, including court applications for grants of probate to allow the proper administration of an estate. Mike understands the strain and stresses of the process and actively fosters communication between parties involved in order to resolve any issues that arise before they grow into conflict. When conflict is unavoidable, Mike applies his knowledge of estate law to estate dispute and litigation matters, including family maintenance and support claims, working in conjunction with his litigation colleagues. Mike enjoys helping clients with their estate planning, ranging from the preparation of straightforward wills and related trusts, enduring powers of attorney, personal directives, as well as working in conjunction with other professional advisors to implement more complex tax plan strategies. Family business succession planning is also a focus of Mike's, working with both business and agribusiness clients. An active member of the legal community, Mike is a member of the Law Society of Alberta and the Canadian Bar Association, including business law and real property law sections, and is past chair of the Wills, Estates, and Trust section. Mike also volunteers as a speaker with the Edmonton Community Foundation. Prior to entering into practice of law, Mike had a 6-year career in retail and wholesale wine and spirits industry and has been active in several political organizations and campaigns. As a partner with McCuaig Desrochers LLP, Mike assists clients with practical advice, drawing upon his business, political, and community experience. Thanks for being here, Mike. And we are also joined by Alison Barkwell. Allison works in all aspects of trust and estate planning administration. Her services to clients include creating estate plans, preparing applications for probate or administration, and advising personal representatives, trustees, and beneficiaries in contentious and non-contentious matters. For estate planning, Allison works with clients and carefully considers their personal situation and objectives. She provides advice to clients on how to best organize their affairs to ensure the unique wishes of each client are carried out. She enjoys working with the client and their advisors, which include financial advisors, accountants, and other professional advisors. Upon the death of an individual, an estate involves numerous legal and financial matters which can seem overwhelming and complicated to a grieving family. Allison understands the emotions and stresses following the death of a loved one, and she can walk the personal representative and family through the tasks at their own pace. Allison knows what needs to be done, how to do it efficiently, and how to advise clients to carry out their duties in a way to minimize liability and future legal problems. Allison and her team provide the necessary assistance to lead the clients through the entire estate admin process. Allison understands how emotional estate disputes can be. She has represented beneficiaries, adult interdependent partners, and personal representatives in all matters related to the estate. She works with clients to identify the issues. She provides options to resolve any issues that come up. Allison believes most claims can be settled prior to a court application and believes negotiation between the parties can be successful and save the clients a lot of money in legal fees. When Allison is not in the office, you can find her running in the River Valley or on the golf course. She hopes to complete her goals of running the London Marathon in October 2021 and the Tokyo Marathon in March of 2022. And I wish I had a glass of water. So without further ado, I'll turn it over to Mike and Allison, and we can hear about what could possibly go wrong. Take it away.
Thanks, Matt. Hi, Allison.
Hi, Mike. Good to see you. It's been a while.
Yeah, it sure has. It sure has. And everything's virtual now.
I know. And usually you bring donuts to our meetings, so I'm really sad I'm not eating a donut right now.
Well, I'm sad I didn't get donuts for tonight too. This is sure different. I've done a bunch of these at rec centers and senior centers and community halls, and I really enjoy doing the talks because you get to see people, you get to interact with them, you get to know if they're laughing at my bad jokes. And this year, I can only tell if you're going to laugh at my bad jokes. So
I usually laugh at your jokes, so we should be fine. And we have Matt to be our moderator in case we turn presidential debate style.
Yes, no, I promise I won't interrupt more than Donald Trump.
Okay, good to know.
Yes, and if you have to say, would you shut up, I'll get the hint. So
okay,
yes.
Good.
We talked about this topic, and we were both kind of excited about it because we both seem to specialize in estates where they're simple and straightforward. There's very little to do, and oh no, it's the other way around. We both end up with files that just seem to always be going off the rails, and there's all sorts of conflict. And we both have a lot of war stories that we like to talk about. And so we want to get into that a little bit. But we thought it would be helpful. As lawyers, we use a lot of words, a lot of big words, a lot of words that mean something to us, but don't necessarily mean something to normal people. And so we thought it might be good to start tonight by just talking about the basics of an estate plan and oh, we're getting feedback. Is it possible if only one of you have their mic on at a time? Okay, we can try. I hope that's better. Oh, feedback, not like people saying, you mean like noise. Okay, let's try that. The basics of an estate plan, hopefully that's better. There's a will. There's an enduring power of attorney, which we like to call EPA. And there's a personal directive, which we like to call a PD. That's our shorthand for it. And when you have a will, there's certain players involved in that will. Allison, do you want to talk about that?
Okay. Oh, we received some feedback that did not make a difference, unfortunately. Well, sorry about that. We're still learning all of our technology during COVID, and sometimes things don't go exactly as planned. So I apologize for any feedback. So moving on to the will, I don't know about you, Mike, but the will, the person appointed that will administer the estate, either if you have a will or don't have a will, we can call them the personal representative. So that is the person that does all of the estate administration. They're the ones that have to deal with the beneficiaries and usually are the ones that want to pull their hair out at the end. Or we can, if the person died without a will, we will call them the administrator. If they have a will, we can call them the executor. So we will sometimes use the three words interchangeably, but if we stick with personal representative, you know who that is. We also have the beneficiary of the estate. So the beneficiary is, we have beneficiaries that receive specific bequests. So they're receiving something from the estate. And then we have the residuary beneficiaries. And those are the ones that are receiving the residue of the estate after all the debts have been paid and everything has been paid out. They get what's left in the pot.
Good explanation. And apparently people are saying it's coming through clear on other people's computers. So maybe it was just that listener, participant's computer. And when Allison talks about estate, an estate is whatever somebody has when they die. So
yes.
You don't have an estate until you, well, it sounds funny. You have an estate, but it crystallizes when you die, essentially. So that sort of covers off the basics of a will. An enduring power of attorney. So an enduring power of attorney, or an EPA, appoints someone to handle financial matters when either you're not able to because of a mental incapacity, or you're not able to and you want somebody to help you with it. The person who gets appointed under an enduring power of attorney is called your attorney. And that gets confusing for people because if you watch lots of American TV shows, lawyers in the United States are called attorneys. In Canada, we're called lawyers or barristers or solicitors, but we're not typically called attorneys. And when we are talking about an attorney, it's the person who is appointed to handle your financial matters under an EPA, which again stands for Enduring Power of Attorney. Did I cover that off, Allison?
I think you covered that off really well. Just to
Okay.
let you know, I have, because this is COVID style, I do have 2 dogs in the room with me, and one is obsessed with birds, and there are birds flying outside still. So if you do hear some barking, I apologize in advance. I don't know what the obsession is.
That's awesome. My dog's upstairs I have a 15-year-old son who's upset that I've said he can't play Xbox and use up all of our Wi-Fi while we're on this. So, different, same thing, different pile. Do you want to talk about personal directives?
Sure. So the personal directive is the document you prepare. It only comes into effect upon loss of capacity, and the personal directive allows the person who is appointed, who is called the agent, to make healthcare decisions for you or personal decisions. So it's any decisions of a non-financial nature. So decisions as to where you would live if you've lost capacity, what sort of treatments you would receive, end of life treatments, those types of decisions, especially now during our current pandemic. Personal directives have become ever so important, as it's the people who would decide if you need to be moved into a home, depending on your condition, whether or not life support should be removed.
And Allison and I are both big proponents of a full estate plan, which is a will, an enduring power of attorney, and a personal directive. Everyone knows about a will. They talk about a will. Oh, I need to get a will. Very few people talk about those other 2 documents. And those other 2 documents are really pretty basic and standard across the board, but they're so important because if you don't have those documents, then it's court applications to get an order under the Adult Guardianship and Trusteeship Act, which has a lovely acronym of AGTA, and you are applying for someone to have a guardian and a trustee, and there's court oversight, and the courts don't like to take people's rights from them, believe it or not. So they'd much rather you voluntarily choose who's going to handle your affairs versus the court having to hear who wants to handle your affairs. So, and that leads into some of the what could possibly go wrong stories, I think. Now,
Yes.
Now we do have a couple of questions, but do we want to hit those first, Allison, and then go into some of the stories?
Sure. So
Okay.
we have a question from Jim S. about specific bequests. So with your estate, he's asking a question, specific bequests be used to help pay for legal, accounting, and other fees. So what happens when you pass away? All of your estate goes to the personal representative on specific trust conditions. And the trust conditions are that they pay all your legally enforceable debts. So those would be taxes. The personal representative is also entitled to be reimbursed for their out-of-pocket expenses. So that would be legal and accounting and any other fees that may have. And once they have paid all of their fees related to the estate administration and paid all the debts of the estate, that is what is left in the residue.
Yep, a great answer, great question. So a lot of people get scared of being appointed an executor and they're on the hook for all the debts of the estate. And I think that's, paying the costs of administering an estate. And typically that always comes out of the estate because you're not expected as executor to incur personal debt dealing with an estate. The next 2 questions are kind of hand in glove. They deal with enduring powers of attorney. There's one that says if you have a spouse then an EPA and a PD aren't necessary because you get that by marriage. No, you don't.
I think you might in BC, but not in Alberta.
Not in Alberta. And given the ever-changing landscape of what marriage is, I don't foresee that ever coming in the future. You still, now, if I'm in the hospital and I'm having a heart attack and they ask my wife if they should put the paddles on me, and she doesn't have a personal directive for me, are they probably going to take her instructions? Yes. But if it's a fight and it's, you know, my first wife, my second wife, and my third wife all deciding on what happens, it could be a problem.
Mike, are you going into all your marriages tonight?
No, I only have one. I only have one. Did it right the first time, but that's why you got to have those documents, because you don't want to have that conflict. Now, the second part of that question is, there are many types of powers of attorney. Is an enduring power of attorney the best one to go with? Well, Allison, what happens if I have a power of attorney and I lose my mental capacity?
Then you've lost your power of attorney. It needs to endure with the loss of capacity. So the other part of the question too, with the enduring power of attorney, you can, depending on where you're at in life and what maybe you're having some mobility issues or something. Some people, when they sign their enduring power of attorney, it comes into effect immediately. And other people, they would prefer it to come into effect at a later date. So there's one that is immediate and one that springs. The springing is if you should lose capacity or if you should decide to bring it into effect at a later date.
Yeah, very good point, Allison. So that's a couple of the questions. Maybe we'll talk about a couple of the stories that might answer a couple of the other questions.
I think they might answer some of the stories.
Yes. Allison, have you ever had any interesting situations dealing with personal directives?
I unfortunately have had lots of interesting situations dealing with personal directives. Really what I think, Mike, you'll learn from Mike and I tonight, it's really important to pick the right person for the job. Don't pick someone because they are your oldest child or you feel guilty. Pick someone that you think is going to make the right decisions for whatever their duties are. So for the personal directive, I recently had an experience where the father decided to appoint his 4 children as agents under the personal directive.
I bet you they all got along really well, didn't they?
Well, what I found out was they hadn't really spoken since they were teens, which seems to be the case. And Dad was now in his 80s, had advanced dementia, and he had very little in terms of assets. So 2 of the siblings thought maybe it's time that Dad be moved to a long-term care facility where he could receive more care, have more people around him to ensure that he was safe. And the other 2 siblings said, no, if you move Dad into a long-term care facility, you are going to kill him. It is COVID. He's going to be isolated. He won't participate in activities. He won't see anyone. So now you have these 4 siblings up against each other, 2 against 2. What do you do?
Go to court, probably.
So it was coming to 2 of the siblings had 1 lawyer. The other 2 had me, and we were fighting back and forth, ready to make the court application.
Yeah, it's always a challenging. People seem to think that they're not hurting feelings by appointing all 4 children, when in fact they know which one knows their values, they know which one's going to do the heavy lifting, but they don't want to step on anyone's toes. They think that they're offending someone to not appoint them. And
That's what, and now these 4 siblings, when dad finally passes away, do you think they're going to speak at the funeral? Do you think they're going to get together for the holidays once we're able to do so? Probably not.
yeah, estate planning doesn't heal family wounds.
No.
Despite what many bad movies have showed people over the years, I've never seen an estate plan bring a family together and reconcile when someone's been ill or someone's died. It's the opposite. I had a situation with a personal directive where I was explaining to the little old lady about the medical decisions and healthcare decisions, and we got to the point where, you know, there was no further hope of her recovery, and what the agent under the personal directive would be making decisions about. And she looked at me and she said, but that means they can kill me. And I said, no, that's still not allowed. She said, no, take that out right now. So I made sure she understood what she was doing, and I did a personal directive that really didn't do anything. And I was very worried that something would happen where it would be triggered and someone would be coming to me and saying, why would you do this personal directive? And I don't know if luckily is the right term, but she ended up passing away without having to use her personal directive. And I was frankly a bit relieved, because I didn't want to have to explain to the children why there was a personal directive that essentially appointed people to not be able to make decisions. So it was a unique scenario, and you do get people fighting over care of the family members and where they're going to live, and I'll tell you, COVID has really made that magnified in terms of how difficult it is for people.
Yes, it definitely has. I know personally in my own life, my parents, COVID has terrified them, and they are terrified that my brother and I may actually send them to assisted living at some point. So they are now in the process of putting in a legal suite in their basement so they can have a full-time caregiver when the time comes.
Well, prior planning, that's a great thing to do. One of the questions which we've probably touched on here is the personal directive better to be one person? What if you put 2 or more, i.e. a son or daughter? Well, as Allison said, you know, if you've got 2 or more and everyone's on the same page, but keep in mind that it can also be very cumbersome. You can have, if you appoint someone who lives in Timbuktu, and right now they're having to tell the doctor what the medical decisions are and they can't be there, it can be pretty challenging. Just taking a look here at some of the other questions.
Okay, well, I see there's a question about the EPA taking money. That never happens, Mike, does it?
No, I've been going through EPAs with people, and they say, but that person could take all my money. And I say, yes, they can. So if you think they're going to, maybe don't pick that person. But the pieces of paper that we give to people, that we prepare for people, aren't going to stop someone who is going to be dishonest. That's not what they're meant for. They're not meant to be a policing document. They're meant to be a guiding and authority document for the people that you're appointing. Have you ever had anyone abuse an enduring power of attorney, Allison?
Yes, I have, unfortunately. I had a matter where mom decided she didn't want to choose between her kids, so she appointed the son and daughter both on her personal directive and on her enduring power of attorney. Daughter and son, they got along fairly well, and they decided that they were going to divide and conquer tasks without seeking any legal advice. And daughter decided to deal with all the decisions of the agent under the personal directive. And she decided to let her brother, who hadn't worked in 20 years, to make all the decisions under the enduring power of attorney. Well, 18 months go by. The daughter decides to check mom's bank account and notices half of her estate is missing. The son decided he was going to become a day trader, which is always a good idea.
What could go wrong?
Topped up his wife's TFSA. He maxed out his TFSA and then put the rest of the money into his investment account where he was trading uranium stocks.
Wow. That's,
Fortunately, we were able to get the money back, and we were able to have him, he agreed to be removed as the attorney. Unfortunately, they were still acting as joint agents under mom's personal directive. Mom needed a new bed, and they couldn't agree on a new bed.
boy, oh boy. It's sad that we see these things, but we do. And I think a lot of the time, as lawyers, we try and deal with our files in a logical approach, and we're able to separate the emotion from the logic. But I mean, you and I, I'm sure, have been there where we're dealing with personal matters that are legal in nature. And when you are involved, you can't separate the emotion from the logic. Try as you might.
Poor
right?
lady, she's like going without a bed, and she needed it. And I was like, why? I'm like, you need to focus on the person that has appointed you and not on your bitterness against your sibling.
Well, and I've seen this. I had a horrible file where there's a very nice euphemism for what your fellow did and what happened on my file. I call it pre-taking.
Happens more than you know.
It really does, and it's people don't understand. In my situation, I had an elderly person with very advanced dementia. Practically speaking, there was no way that he was going to be able to change his will.
Right.
But technically, under the law, he could change his will until he dies. And the attorneys decided that they would just start advancing millions of dollars to the beneficiaries before he died. All the beneficiaries, oddly enough, were in favor of this because they were all getting money, but it went off the rails when it started to be unequal. And then there was a big fight with, unfortunately, numerous court applications and lots of venom and hard feelings where unfortunately, these people were fighting, and in front of the judge, he was rather perplexed because he said to them, but it's not your money. And they had a real tough time understanding the fact that until someone dies and a will becomes not just a piece of paper, but becomes the estate, you can't just willy-nilly take their money and distribute it because you think that's the way the estate's going to go. And so there are a lot of times where these enduring powers of attorney get put in the hands of people that are not equipped to handle them. Ironically, you would think when there's less money, there would be more problems. I tend to find when there's more money, there's more problems because for whatever reason, it just, well, if dad has $20 million and we take 10 ahead of time, he's still got $10 million, so it's not a problem. But it's still wrong. And
Yes.
And so there's lots of bad situations with enduring powers of attorney where you get fights with people, where you get that pre-taking, as I like to call it, so it doesn't sound, I think pre-taking is nicer than stealing, isn't it?
Yeah, it's nicer than stealing. Mike, for your enduring powers of attorney, and this is something I always encourage my clients, is to have an accounting in the enduring power of attorney, so that the person who is the attorney has to account to someone. I know I've had clients saying, oh, but I trust Jimmy and he won't do anything. I'm like, but as you said, I think maybe that was earlier, we were talking when the suspicion of silence, or what was your comment? When there's silence or suspicion?
Oh, silence equals suspicion.
Yes.
That was Professor Hopp that used to say
okay, that. Silence equals suspicion. So in the enduring power of attorney, I always recommend that there be an accounting, and that there be an accounting at the request of someone. So if you've appointed one of your children, that the rest can request an accounting at any time, or that there be an accounting on an annual basis, so that the attorney has to show where mom or dad's money has gone.
I think that's a great idea, and it actually shoehorns well with a question about an attorney who's also a beneficiary making changes to the assets.
That happens.
Yeah, and you know, I have something in my form of enduring power of attorney that says that the attorney is permitted to see the will, so that they govern the affairs of the person in a manner consistent with the will. So if the will says, I want my silver tea service to go to Susie, they don't go and sell the silver tea service, because it will defeat the purpose of the will.
Right.
And so that they govern their affairs. Yeah, and I think when you have a properly prepared document, it contemplates some of these things, that because we've seen the problems, right?
I also have that they can't change any beneficiary designations. I did encounter an issue where there was some RRSP was moved, or sorry, a RIF was moved from one account to another, and they changed the beneficiary designation after seeing the will to ensure that it went to the estate, where the attorney fortunately was the sole beneficiary.
Yeah, and even when you put that in, there's end runs around it, right? And just because it says you can't do that doesn't mean that it doesn't happen, right? Again, you're trusting the person that you're appointing, which, you know, there's a question about what if no one wants to be my executor, and it also applies for if no one wants to be your attorney under enduring power of attorney. You know, once, and I'm sure, Allison, you've had people say, oh, you're my lawyer, you can be my attorney, or you can be my executor. And you probably jump at every opportunity, right?
I tell them that I would actually probably be a terrible executor, because I have a full-time job and I don't need another one.
Yes, and it is a full-time job. So there are options out there. There are a number of different trust companies, usually connected with one of the major banks, that will be an executor or attorney for a fee, and you can meet with them and decide if you're comfortable doing it. They are not inexpensive, but they are very good at the jobs they do, and they have all sorts of institutional structures in place that can be very advantageous. For example, if you've got a vacant property that can be very difficult to insure, well, if you've got a large trust company that has a blanket insurance policy, they can often insure a property that an individual executor or attorney might not be able to. So there are pros and cons to that, but that is an option in terms of when you don't have somebody that is either willing or able to act in those roles for you. But
I also tell Right.
Oh,
I also tell clients, if they do have someone, but they might be too busy, that they can hire the person appointed as the personal representative, can then hire a trust company to act as their agent. And as their agent, they can do all the crappy jobs like going through the house and checking through every book for money and under tables and doing all the stuff that, Mike, I'm sure you do in your spare time as executor.
Who told you where I hide all my money? Both dollars. And speaking of money, one of the questions from Margaret is, what are the costs of all these legalities? So Margaret, I'm guessing you're asking about the cost of a basic estate plan, because dealing with the fighting in the estates is a whole other ball of wax. I think for an individual, it really depends on your circumstances. To do all three documents can range probably between, depending on the complexity, I've done them probably less than $1,000, and I've done them for many thousands of dollars if you have disabled children, or you have assets.
Blended family.
Yeah, blended family, assets outside this jurisdiction, all sorts of complicated businesses, business structures, those types of things. But would you say that's about the range, Allison?
I would say that's about the range. It really depends. I know most people, I'm sure this happens to you, Mike, people come to you and say it's really simple.
Mm-hmm.
And then you start doing the deep dive and you find out that it's a third marriage and there's a child that may be disabled and there's spousal support issues and all sorts of stuff going on. And then usually the cost may go up depending on the situation. Every situation is unique, and it's really important for the client to explain to the lawyer. It's not just a cut and paste job. I know sometimes people think that's what we do. We just cut and paste documents. Yep. And I think our estate planning is unique. And unfortunately, after you're incapacitated or you've passed away, you can't change it. So I do recommend spending the money to actually go see a wills and estate specialist. As I've told my parents, I'm like, you wouldn't go see your GP for heart surgery, so why would you just go see a general practitioner for a will?
Yeah, it's I specialize in cliches, so it's the ounce of prevention versus the pound of cure. Yes. You can spend a little bit on a good, relatively speaking, a little bit on a good estate plan versus what I sometimes have to deal with, what I call post-death estate planning, where someone's got such a bad estate. I'm dealing with one right now where there's a bad estate plan and we're having to get an agreement in place and a court order to redistribute the estate in the way it was meant to be, not the way it was written.
That happens unfortunately too often.
Yeah, and I'll tell you that ounce of prevention would have been a lot less expensive than the pound of cure that we're dealing with now.
So should we move on to talking about wills, since we have so much to say, and I'm sure people don't want to be on our Zoom meeting all night, although it's really nice seeing you, Mike.
Hey, likewise. I don't get to see anybody anymore, so you're on your house and I'm in my basement, and I spend a lot more time down here. My wife, as soon as COVID hit, said, yeah, you're not working at the dining room table. I'm setting you up in the spare bedroom. So
that's
at
nice.
least it was for work in the spare bedroom.
We don't need to know anymore.
No, not at all. So wills, where do you want to go with that, Allison? You want to talk about some of the horror stories you've had on estates and wills?
There's so many, unfortunately.
Yeah, but I want you to go first so I can one-up you on this. So.
Okay. Let me see. Choosing the personal representative, Mike and I, we just actually, because we wanted this to be more like a duel between us and wanted to one-up each other on stories, we have not actually practiced this presentation, and we're just coming up with our war stories off the cuff. One of the worst estates I dealt with was where Dad had prepared a will. He decided that he was going to appoint his 3 children as the executors. He was in a third marriage, and the children hated the third wife. The children also hated each other, and the will did not have what we call a majority rules clause. So the majority rules clause in estate administration would allow any 2 to agree on a decision to move the estate forward. Unfortunately, in this situation, he just went to his local lawyer in small town Alberta, who practiced everything, which is great. And he's like, I'm appointing my 3 kids. I don't really know the situation, but the kids hated each other. Like from the time they were 17, they hadn't spoken to one another. They're in their 40s and 50s. And now we have this estate. Dad also didn't get legal advice on how to properly provide for the 3rd wife of 30 years. So there was a family maintenance and support claim. And because he was a farmer, he gave less to his daughter than he gave to his sons.
Great. Always a recipe for family harmony, eh?
So suddenly, an estate that could have been relatively simple to administer had there been maybe 1 executor became a huge nightmare. Suddenly we go from 1 lawyer on the file to 8.
Wow.
5 years later, they're still fighting out of principle.
Yeah, well, I always like the expression, if you want to stand on your principles, you get them dirty with your feet. So,
so they fought over everything. They fought over photographs. They fought over belt buckles. They fought over anything they could fight over. And they ended up spending tons in legal fees, unfortunately. But I think in this case, if the testator, Dad, had told his lawyer that my kids don't get along, my wife hates my kids hate my wife, then maybe in this case there would have been a trust company appointed and it would have been relatively smooth. As smooth as it could be, because they could lash out at the trust company rather than one another.
Yeah, it's I think a large part of what we do and the benefit of dealing with a lawyer that is going to spend the time is doing that deep dive and getting down to the truth of the relationships. It's a strange thing to say to people, but we need to know everything, and we need to know it because we need to know that the person making the will knows it, and we need to explain to them that they're entitled to do whatever they want with their estate, but they better understand the ripple effect, the pebble in the pond, and the consequences of their choices. You know, giving the daughter less because it's a farm family. Well, if those kids were getting along before, they sure wouldn't have gotten along afterwards because of the way the estate was distributed, right?
And it's also, for me, I always tell my clients, and I don't know if you tell your clients this, is better to be transparent. I know I have my little old lady clients who want to keep the will a secret to make it a surprise. But if everyone knows, then it can be discussed beforehand and there might less likely be hurt feelings or families not getting along.
Absolutely. I had well, 5 years seems pretty short for a contentious estate file. I've just finished one after 10 years. And it was my file to end all files. There were 56 bank accounts in 9 countries. And I really thought the deceased was like a secret agent or a spy of some sort, but unfortunately he wasn't. Yeah, no, well, I can neither confirm or deny. But it was unfortunately a very tough estate. His elderly brother was the executor who wanted to honor his wishes. He was a very wonderful, sweet man, but he was just basically in the crosshairs of fighting children for too many years, finally couldn't take it anymore and had to step back. We had to have someone else appointed, another lawyer appointed as the replacement executor. And it was just a horrible, horrible scenario where we spent probably more time in court than we did just talking. And not for lack of trying, but everybody distrusted everybody else. And at the end of the day, two of the children decided to just take a smaller amount and walk away, and two of them kept fighting until one of them died. And it was as much as I saw everything there was to see in dealing with an estate on every facet, it was still a very difficult file, because for the lawyers, we could see the solution. We could see where this was going to go, but the fighting children kept hiring and firing lawyers, and they wouldn't take legal advice, and there's probably some mental health issues wound into all of that. And at the end of the day, the bag full of jewels that there was to get appraised turned out to be costume jewelry quality, and I think we paid more for the appraisal than the jewels were worth. So as exciting as it was, it wasn't a successful file in that respect. And unfortunately, it was an old estate plan and a complete lack of transparency, secrecy, accounts hidden all over the place. I still fear we're going to have someone write to us and find one more bank account someday. Just checking out any of the questions here, Allison. I think we better, Matt, I know you're listening in. We said that we'd go for about an hour. I think we're about 10 to 15 minutes away from the end here. So we can sort of keep going and talking about some Will's stories, or we can tackle some more questions. Allison, what do you think we should do?
I will leave it up to, if the audience would like us to answer some questions, I'm happy to do that. And Matt?
There seems to be a few questions in the chat that I'm sure some folks would like to have some answers to. So if you wanted to go through that, feel free. But if you've got a couple more stories, feel free to share those as well. Really up to you guys.
Okay, I didn't realize the chat scrolled so far down. Yeah, we better do some questions. Steps to get an EPA and PD signed, i.e. doctors, etc.
Okay, so this question from Sue, I'm assuming, sorry, my dog is now, one dog is sitting on my lap. To get the EPA and PD signed, if you mean to bring it into effect, usually the EPA and the PD, they just usually need one witness to have it signed. But to bring it into effect, it really depends what is in your documents. The legislation for both for the Powers of Attorney Act and the Personal Directives say that 2 doctors will bring it into effect unless you have something else in your document. Me personally, I have 1 doctor plus one of the people I've appointed. My fear is that maybe I'm just having a bad hair day and the doctor says I don't have capacity, but at least my attorney knows me well enough to say, oh no, she's just having a bad day.
I might be having a no hair day, but yes.
So that's my personal view, but it's really up to you. Some people have 2 doctors and one of their attorneys. Some people just have 1 doctor. It's really a personal preference.
Yeah, I've switched to recommending 1 doctor simply because if you're dealing with someone in a care home,
yes,
there's usually a primary physician, but getting a secondary physician to give an opinion can be very challenging.
Yes, I agree with you, and I have switched to that, but you do have those clients that want 2 doctors, and the client is usually always right.
Yes. Personal directive only used when a person's hospitalized. Well, that's a good question. Depends on the circumstance. So if you have someone moving into a seniors facility, they will almost always require that the person have a personal directive and an enduring power of attorney. Enduring power of attorney because they want to make sure someone will make sure their bill gets paid, and a personal directive because they want to know who they can have make decisions. So if a person has dementia or some other incapacity, they might be decisions about whether they participate in getting a flu shot this year, or whether they participate in a trip to the zoo. So it's not just when they're in the hospital. That is, though, when most often there's an emergent circumstance or a long-term health issue, and where they want to know who is making the decisions, who has a legal authority to make the decisions.
Last year I was having an anaphylactic reaction to dandelions of all things. And I ended up at, I know, weird allergy. I ended up at the U of A hospital at 1 in the morning on a Thursday. And actually when I was going into emergency, because I took myself to emergency, they did ask me if I had a personal directive, and the nurse didn't understand why I was laughing, because she was like, well, do you have it with you? And I'm like, no, but I should. So
Yeah.
that sometimes in the hospital, if you are going to emergency, they will ask you to provide it at check-in.
Yep,
which
I've
now
seen that
learned.
as well. Is an EPA the same as a trustee or executor? So an EPA, an enduring power of attorney, is the attorney is someone who handles things while you are alive. A trustee and executor is when the person has died. So they're similar in terms of dealing with financial matters, but an enduring power of attorney endures past an incapacity, but once someone dies, it no longer has any force and effect.
Okay. What are your views about passing of accounts and whether the cost of this is worth the effort? So
I think that's fact specific. I mean,
it is fact specific. At the time that there is a distribution of an estate, the personal representative of the estate will give a full accounting of the estate from the time of death to the date of distribution, or if there's already been a distribution, then from the time of the last distribution to the time of the next distribution. At that time, the beneficiary of the estate can review the accounting. If they have any questions, they can ask the personal representative to provide receipts or more information. It really depends if the information's not being provided. I'm of the view, though, you should always try and work with the person before making a court application to see if you can sort things out first.
Yeah, no, I agree. Is it okay to have different person on each document, the will, EPA, and PD? Does it make a difference if they're living in a different province? Yes, it's okay, and quite often you'll have different people. Very often I'll have clients where one of their children's a medical professional and they name them under the personal directive, and then the other child's an accountant or a lawyer and they name them under the enduring power of attorney. Does it make a difference in their different province? So with technology, it probably doesn't make a difference. It's more a logistical issue. So if someone's going into the hospital and you're having to talk with the doctors or you're having to make medical decisions, can you do it over the phone? Yes, or by video chat. Is it as good as being there and seeing the sick person and knowing what they're going through? That's really a personal decision for people, but it's definitely permissible. It's just whether it works for your circumstances.
Okay, next question. Is it okay for someone with a power of attorney to change the beneficiary designations for something like a TFSA or liquidate a TFSA that has a beneficiary designation? The short answer is you could move the TFSA to another financial institution, but you need to maintain the beneficiary designation. To remove it would be going against the person's wishes, and the estate may actually benefit more. If an attorney did that, they could get sued.
Yeah, I think the short answer to that one is no, it's not okay.
No.
Yeah. You know, someone's asking about what happens when you die without a will, and we call that an intestacy. And when someone dies without a will, they're said to have died intestate. And as we talked about before, there's a default set of rules that exist, and we won't go into them fully tonight, just because they're fairly long and a little bit boring. And the default rules can work okay, but we've probably both seen files where you have those default rules. I had one where even an old will, and it was everything to my wife, and they'd been divorced for 25 years. And luckily, they were on good terms, and the wife decided she wouldn't take the gift, so it went to their 2 children. And it was a feel-good story, but you can have situations where there's unintended consequences. If you're still married and you die without a will, and you're not in another relationship.
And just extending that, Mike, I'm sure you have seen this, is if your relationship status changes, so if you were married and are no longer married, take a look at your beneficiary designations on your life insurance policies, your RRSPs, your TFSA. Also check on how you own things like the family home. So you and your spouse separate, and maybe you don't get divorced, but or you're separated for so long and you decide not to deal with divorce proceedings. Who really owns the property? I know I've had situations where I've had very upset people because the wrong person is either receiving the life insurance policy or the house or something else, because people have not updated those matters along with their estate planning documents. I'm sure you do this, Mike, too, but when people tell me how they own something, I always pull title just to check.
Yes, and sometimes your client's the right person who ends up with the property, Allison. So, you know.
Depends on the file.
Yes, it does. It very much does.
So it's something as part of the estate planning. It's really important that you may not understand how you own something, but at least the lawyer advising you can check things to make sure that things are properly owned, and if maybe property needs to be transferred into someone else's name, or sometimes people own property as joint tenants, which means upon the death of one of the individuals, it passes by right of survivorship. And that wasn't the intention when the property was purchased. So they may want it to actually, their 1/2 share to go into their estate and be transferred to their children.
Yeah, I think we've talked about some of the bad things, and Matt, I see you're back on the screen, so you're probably going to wrap us up. There's one question there that just talks about common situations that cause matters to go sideways, and I just want to echo what Allison said. Lack of transparency. I think that what people suspect is always worse than what the actual facts are. And I deal with this over and over again, where I'll have a call from a very upset beneficiary wanting to know what's going on and where their money is and why it's being stolen. They seem rather disappointed when I tell them, actually, everything's proceeding the way the will is written. That's what the executor's job is. I'm acting for the executor. The executor has an obligation to pay all the debts and deal with the taxes and etc. And you know, an average estate is 1 to 2 years to deal with, in dealing with distributing the assets and getting a clearance certificate from Canada Revenue Agency, and depending on the scope of the estate. So I tell clients when they make an estate plan, go talk to your children, go talk to your spouse, go talk to your family members, tell them what you've done, because there is no reading of the will, there's no matlock moments where someone pulls a piece of paper out and the big surprise aha. That's what fosters more problems in estate law than anything else. The lack of transparency, as Allison mentioned.
I would agree, Mike. I'm sure you have the videos that you pull out, and it's the person speaking after they've died, telling them what's gone and why they've removed people, like the movies.
Yeah, I try to talk people out of that.
I've never seen that. I think too, it's really important that once someone passes away to understand the timelines. It is a year to 2 years for a average estate.
Mm-hmm.
On the estates that go sideways, Mike has said 10 years. I did have a residuary beneficiary show up at my office a month after her dad died, demanding that I give her $30,000 because she just bought a trailer. She was very upset with me when I told her I couldn't give her the money and that we haven't even applied for the grant of probate as of yet.
Well, that trailer was probably part of her healing process, Allison.
Maybe. I told her to call you. You might loan her the money.
Oh, sure. Absolutely.
Well, I'm glad you guys ended up answering that last question, because that was the one that I was going to direct you to close on, but you read my mind. So thank you for doing that. I want to thank you both for taking the time to be here and chatting with our attendees, answering a bunch of questions, sharing a bunch of horror stories. I think the biggest takeaway that I hope everybody learned from this is that really call one of you guys and get this done right so that there aren't these issues when it comes time to have to deal with any of this stuff. So thank you very much for everybody for being a part of this. Thank you to Mike and to Allison for sharing their experiences. Hopefully it's provided us with a lot of know-how going forward that even though you're lawyers and it's sometimes scary to chat with you guys, it's probably for the best long term. So thank you all very much.
Thanks, everyone.
Thank you for having us. And I'm sure Mike would say the same. If anyone has any questions, please feel free to reach out to us personally by phone or email, and we're happy to answer your questions.
Absolutely. And big thanks to the Community Foundation. I think,
yes.
I think they get lost in the shuffle on all these. I mean, I know they have the fancy background behind Matt and everything, but they do such incredible work and promote Wills Week every year. And we're very fortunate to be able to work with them and have them as such a big part of our community.